Welcome to the New South Wales Government's Business Connect webcast on business disruption. My name is Steve Waite, the Business Centre CEO and a Business Connect advisor. This episode is our second on unpacking the current challenges of staff returning to work and employers' legal rights and responsibilities during the COVID-19 disruption. Our guest today is Michelle Dawson, Principal Lawyer at DWF, who was with us on our very first webcast on industrial relations and workplace law right at the beginning of the COVID-19 pandemic in March. Michelle joins us now again to update us and help us understand what this evolving workplace and employment situation means for small business owners who employ staff. So acknowledging employees and your organisation are your most important asset, I think, as we all understand. So this particular conversation, we're going to look at unpacking that a little more and looking at those rights, the sorts of things, although we won't hone in on everything to a microscopic degree, but some of the things we're going to concentrate on are returning to the workplace, pay and leave during the coronavirus, stand down during the coronavirus, alternative working arrangements, ending employment and redundancy, health and safety a little, and temporary changes in workplace laws during the virus. So we'd encourage you, as always, to ask questions. They'll come through live. And if we can't get to those questions during the webcast today, we'll certainly record an extra session at the end where we can look at those questions we don't get to cover today. But time for Michelle, and we'd very much like to thank you again for coming along, preparing for this webcast. And I guess putting together, we were talking before this, putting together what it was like in March and the unknown elements, and now there are some knowns, but there still are some unknowns. And we want to start to look towards that now. And one of the things, Michelle, that we've spoken about that seems to be coming up, and we'd just like to get a sense of that from your perspective, is this staff returning to the workplace. What are some of the, and there's a date coming up that we know around that in regard to work and work patterns, but what are you picking up as key themes there?
Yeah, sure. Look, essentially every business is going to contend with and have different considerations to be had around how they're going to return to work and what that's going to look like for them. Obviously, the social distancing requirements that are still in existence are impacting the decision making around a lot of that. Yeah. You have a lot of people in different industries where they might have offices or an office area as a part of their overall operation. Mm-hmm. For instance, we're also seeing it in restaurants and cafes. It's affecting, the numbers of people who can be under the roof, quite apart from the maximum capacity levels that are otherwise mandated. So a lot of it is depending upon how people's workplaces can in fact function in light of the social distancing obligations and requirements and complying with all of the directives in that regard. So everyone's kind of having a different story to tell and having different experiences around that at the moment. What we're seeing is a real an approach whereby people who are okay, perhaps working from home in businesses where that's available, are continuing to work from home. People who may not be working from home as well as they could be, whether that's from a productivity standpoint or a mental health and wellbeing standpoint, perhaps, or it's too much of a juggle having children and I really need to be in the office so that I can do these things standpoint. There's really becoming a bit of a mixed approach to what some of the workplaces that we've been working with are actually doing. So what we have is, on one level, a restoration to some form of normal for some components of workforces, as well as a continuation of the very quickly implemented working from home arrangements for many. And, you really have a bit of a hybrid scenario going on at the moment for different people.
Can I jump in there, because we spoke about maybe towards the end of our conversation today we might look at that impending 28th of September date and how that plays itself back through to now. But one date that you alerted me to was some of the temporary provisions that were made in regard to the Fair Work Act about bandwidth and the hours that people can work.
Yeah.
Can we talk about that a little bit and what that means and what people have to do?
Yeah, sure. So, look, essentially the last time we spoke back in March, there had been, at that point, it was very early in the piece, there'd been quite limited legislative or regulatory parameters put into place. We were working with a situation where we essentially had a previously largely underutilised set of stand-down provisions under the Fair Work Act, and that was about all that was available and open to people at that point in time. And that carried with it, along with some of the jurisprudence, so the case law around that, carried with it some quite strict parameters on, you know, do we need to stand down the entirety of our workforce? Can we just stand down proportions of our workforce? How can we quite contend with this? And of course, since that time and as time progressed, there was the introduction, of course, of some changes. Some of those changes were input into some of the modern awards that our viewers will all be working with in different respects and in different degrees across their businesses. And we also saw, with the introduction, of course, of the JobKeeper regime, we also saw some temporary amendments made to the Fair Work Act around pandemic leave, the ability, for instance, or a more easy ability, essentially, for employers to have employees, direct employees, to take leave, and perhaps to be taking, leave with different types of arrangements to those that might otherwise have been accessible previously.
And then the hours as well, wasn't there, like the bandwidth?
Yeah. So there was the ability to reduce people's hours, essentially, and those types of things, whereas prior to the introduction of those provisions, we'd been significantly reliant upon the ability only to vary someone's hours by mutual consent through almost a common law type approach rather than a legislative type approach. So those sorts of changes have made things easier for employers to essentially best place them to continue to, operate at least to some extent. But some of those changes are about to fall away.
So 30 June,
So originally a number of those changes introduced specifically to awards in particular were only introduced for a temporary period, and some of those are due to fall away on the 30th of June. There has been a little bit of noise this week coming out of the Fair Work Commission suggesting that some of those provisions might be extended, given where we find ourselves in the phase of the pandemic.
Just on that topic, because we were talking about this a little bit beforehand. So if, as a result of this pandemic, we've negotiated as an employer with our staff, we have some alternative or, some flexibilities that we put in place, and we find that as a result of this disruption, they're working quite well. And we'd like to continue them, but what you're inferring there is that it's possible that those arrangements would fall out of what would normally be legal or within the award, how it's expressed. So we would have to do something about that to continue to enjoy the success of that.
Yeah, sure. So yes, there may be some extensions to some of those award-related provisions, but irrespective of whether or not there are extensions, they are going to remain, at least to the extent of anyone's knowledge right now, temporary. Excuse me.
Yep.
Essentially, what that gives employers and employees an opportunity to do, particularly in the example that you give about people who might be working very well from home, no impact on productivity, in some respects, increased productivity, opportunities to revisit the way they've engaged their staff and indeed with their staff in the past. And there are provisions in modern awards that are there that can help to facilitate some of these arrangements on a more permanent basis. Things like individual flexibility arrangements under a modern award. Modern awards generally will prescribe particular parts of the award which can essentially be varied by appropriate agreement with employees, provided that those changes still meet the better off overall test.
Yep.
So that they don't fundamentally operate to the detriment of an employee. They are things that are in awards and they are permanently there, but in my experience are often quite underutilised, particularly in the small to medium business sector, because they're actually not that difficult to implement, but they do carry with them a degree of complexity. I mean, as soon as you say to a small business operator in particular, all right, well, we just need to make sure that this passes the boot, the better off overall test, people go into freeze zone, because that's not a straightforward concept.
So at a practical level then, for an employer, a small business, they need to probably get some advice at the front of that process, because it may be giving them success. They don't want it to go astray or become a risk. So they need to follow a due process, which is worth the investment of time. So probably setting it out in some written form, get that potentially checked by a person who has a sense of the legalities of that, what can and can't be done, and then it's set in place. Is that?
Yeah, look, that's exactly right. I mean, regularly, as you and I were discussing earlier, there's a real reluctance on the part of people sometimes if they look at something in an award, say, and it appears quite complex, difficult, or potentially it looks at first blush like you'll get a fair bit of employee opposition. There's an automatic resistance to actually trying to utilise what it provides. Something that we find is, employers are often grappling with finding solutions for issues that they have, and they're doing that on their own, often trying to make the most of their own understanding of the award that they're working with. We find that with our clients, when they're talking to us, when they're having those problems, engaging us at the point in time that they're looking for solutions, getting in front, getting in front of the issue, investing the time, and often our clients are surprised at, how quickly we can help with these things, and therefore, the cost implication is not as great as they think it might be. If we can engage with our clients around creating solutions and getting in front of these issues, the amount of time that they save in either having a crack at some other way of doing it and falling foul of some provision that they would never have understood to have existed. There's not usually any deliberate intentions here.
Because we were talking earlier as well about having a crack at it, because there are things that have come out of this that are beneficial about the way people are working. But we do have a process we have to follow, but you can capture a local or an enterprise-specific solution as long as you get the way that you set it out checked to move ahead.
And as long as you engage with people who've maybe worked with the awards with a little bit more regularity, or for a few more clients, and across other types of businesses, so that you can understand what opportunities are actually already there and exist for you within the awards. We and even all of the various industrial associations, who are another great source of knowledge and assistance to business owners in these times, but in any times, reaching out to someone who might be able to add some value into the building of the solutions, rather than looking at lawyers as a back-end solver of problems. What you will spend getting it right at the front will often be much, much less than what you will ultimately spend if you do get it wrong. And as I say, employers don't generally go out of their way to deliberately do the wrong thing. It's usually a case of just not having understood that there might have been a better way or a more risk-averse way to do things. And, the other piece to all of this too that I see sometimes employers miss is, if you have an issue and you're thinking to yourself, for instance, this person works really well from home, and it's actually working well for us for that person to be working from home 2 days a week and coming into the office 2 days a week, and we actually probably don't even really need them on that 5th day. How do we contend with that? The piece that they often miss is sitting down and having a conversation with the employee, because they may well be on the exact same page, especially after what's transpired in what has been an unprecedented and quite stressful time for people, and it's enabled people time to reflect and perhaps reset, reprioritise. Having that conversation and actually understanding what they want, you might find there's some real alignment with what you want, and in fact you don't even perhaps need to look to some of the broader based solutions if you're both on the same page.
And then set it out and get it checked.
Document it. Get some help to make sure it's not falling foul of one of the award provisions that apply, making sure that it's not going to otherwise undermine any perhaps provision of the National Employment Standards or any of your existing or residual contractual provisions, making sure that the existing contract and the variations to that are interacting in the way that they should to give you as a business the best form of legal protection. All of that stuff is invaluable.
Yeah, and as you were saying earlier, it could be at quite a low cost. Instead of engaging someone at the other end when something might get messy or complicated, you could invest a very low amount of money as a small business in getting some clear, sound advice and getting something checked. It'd be a very low cost burden, wouldn't it?
Yeah. Look, often we can fix these issues in an hour or two or less. So it's important to think about that, particularly where people are reluctant to spend money at the moment, completely and utterly understandably. It's a bit like an insurance policy.
Okay, now we might move our conversations we spoke to beforehand. We've got some questions coming through. We'll get to those. Before we get there, though, I'd just like to set up where we might be heading, which is this impending date of the 28th of September. We know that we've got the 30th of June in regards to some of those provisions in regard to the way people are working. However, there's another date on the 28th of September. We'll work towards that and some of the questions that brought up for us. But let's just look at something here we've got coming through. Okay, from Bell. The majority of our team believes they have been more productive working remotely. They are not keen to return to the workplace. How do I address this legally? Can they say staying remotely, bringing them into work would be against their wishes? Can they say, I'm not coming back?
Yeah.
I know you can only answer generally, and it's just a conversation, but what are your thoughts?
Yeah, sure. Look, ultimately, management prerogative is still a really important thing. Businesses are still going to be in control of what works for them on an operational level, and there are very few regulators or indeed the Fair Work Commission are generally inherently reluctant to interfere with management prerogative around some of these things. The things to watch out for in that type of scenario are the reasons that people perhaps might want to stay working from home. So if you have a situation perhaps where someone has carer responsibilities in some way, shape or form, and they want to continue to work from home to help to facilitate those carer obligations, you need to be careful as an employer not to decline their requests to continue to work from home in some way, so that you are ensuring you're making appropriately reasonable adjustments from the point of view of the anti-discrimination
legislation. Unilateral. You can't do that. We know that we've got a provision and we have a conversation. A lot of these things need to be assessed on a case-by-case basis. At the end of the day, employers are still going to be entitled to reasonably direct their employees to do things the way that they want them done, as long as it's reasonable and as long as it's lawful. Okay, we've got another good one here, which is something we've hit on. Mel asks, our team is considering moving to a 4-day work week. What are the pitfalls to look out for? Have you heard of or experienced any issues of teams moving to this structure?
So a 4-day work week and introducing a whole new method of work essentially is largely going to be something that if you can get your employees to agree, if they're on side, if that's something that they are content with, because it will ultimately, inevitably, at least in most cases, result in a reduction in overall hours for that employee. Employers can't, as a general proposition, unilaterally, as in on one side, force their employees to make those changes. Obviously, there would be important financial and other pragmatic considerations for employees around that need to be considered as well. But generally speaking, where you have alignment with your employees that's going to be okay to do, it's a relatively easy proposition to roll out. Where it becomes more difficult is finding yourself in a position where you need to force that situation, and that's the point in time at which advice should be sought, because it's not a one-size-fits-all answer.
No, it's quite a structural decision with some complication.
It is, and there's inherently variables in every situation to be contended with, and that's not just variables from business to business, it's variables from each employee within each business as well.
Here's an interesting question. I'm going to go to that one there on the visas. Yeah, Jane asks, some of my staff are on work visas. What should I advise them if I have to stand them down?
Yeah, okay. There are really strict rules around giving advice in relation to visas and migration law. I'm not a migration agent, so unfortunately I can't answer that question, because I would be doing the wrong thing if I did. But certainly if the asker of the question wanted to reach out to us separately, I can make some connections.
There's another interesting one here, which I know is of interest to a lot of employers as people are seeking different ways of working at a point like this. But this question is from Sandra. I want my team members to stay with me as contractors, not employees, through these hard times. What are the main considerations I need to take into account? Yeah,
sure. So there are some real inhibitors to that type of situation coming about. The most significant inhibitor to that factor are the sham contracting provisions contained within the Fair Work Act. So it's actually unlawful to terminate someone's employment to re-engage them as a contractor.
In black and white, that's what it says.
In black and white, that's what it says. Look, you often find people looking to the grey for solutions. Unfortunately, those grey solutions aren't always ideal and are usually not ironclad ways of ensuring that you're staying out of regulatory strife. So my recommendation would be, and it does vary sometimes from a case-by-case point of view too, in terms of, you know, what the structure actually is and what you're looking at from an employee standpoint.
Let me put a hypothetical only, but what if an employee said, look, as a result of this, I've found, I've got a different view of the way my working week and my personal life operates. I'd like to no longer be an employee. I've been here for 15 years. I believe I'd be able to receive some redundancy. I'm putting myself forward for something like that. But I would like to stay in touch with the business. I'm doing some other work. Can I become a contractor?
Yeah, so often that scenario does come about. The arrangement for an employee to become a contractor is at the initiative of the employee. That's cleaner territory insofar as from a legal point of view, but it's still not perfect. And, you know, in that situation in which you describe, you know, that would certainly be a much cleaner situation than the approach being from the employer to the employee. But it's still not a perfect situation, and it's certainly something that specific advice should be taken around. The other thing about engaging as contractors is, for businesses, there are some real risks that exist in contracting arrangements coming about. And a lot of those risks are overlooked, particularly I find in small business circles, where there is there are a lot of myths in this territory. A lot of people are of the belief that if someone has an ABN, then they can be a contractor, and that essentially absolves any issues. Pardon me, that is a myth. That's not right. You know, there are people, even when they become contractors for other intents and purposes, they will still be considered to be employees for the purposes of some legislation. So in particular for superannuation purposes, there is in the superannuation legislation what we call an extended definition of the term employee, and that will capture many individual contractors. And so what we see there is a risk creeping in whereby employers think, okay, we don't have to remit for superannuation to that person anymore, when in fact that's not right. And the only real way, and there's not a one-size-fits-all approach, but the only instance in which the superannuation liability can actually be shifted to that contractor is where there is an intervening proprietary limited entity, or perhaps a trust or some other legal entity.
Your response to that question tells me that the asker of that question really is in territory where they need to get professional advice. My brain was starting to hurt with all of the parts of considerations
I have that effect,
coming into play there. So it's clearly an area which people probably need to get some professional advice on. We've got one more question, and then I'd like to move towards our September 28 conversation. This is an interesting one because we're talking about innovation. So this is a question, I guess, around that. Are IR lawyers across industry, not specifically for your employer or the firm that you're working with, are they offering fixed-term solutions or fees as a way of taking away the fear for the cost of advice? Is that type of model starting to come into play in the industry?
Yeah, sure. So law firms historically have been creatures of habit. Very conservative, work on we charge in 6-minute increments and that's the way we do things, and if you don't like it, move along. These days, law firms are largely becoming more responsive to what it is that clients want and what clients need. In our firm at DWF, we do offer fixed fee solutions for our clients around different things. People want that. They want the certainty. They want to know what it's going to cost, and they want to, avoid any fee shock, which unfortunately lawyers have a really bad rap for instilling in people. So the answer is broadly yes. If you have a conversation with the law firm that you work with, generally speaking, a lot of them these days will offer that as a solution.
And now may well be, as we get closer to this last question, a time where it may be better to engage someone for a period of time because you're going to be going through some important decision making in some areas that you'll need advice around what you're doing in your business, the risk, the labour costs, etc. Before we go to that though, we've got one last question we'll include now. It's a really interesting one. Dave asks, there's been a lot of news around retail workers being assaulted by customers when enforcing social distancing rules. Should I consider developing a plan that will protect my business in this scenario?
Yeah. So obviously that constitutes some occupational health and safety issues. And so as employers, all employers should be taking reasonable measures to ensure the health and safety of persons in their workplaces. So the answer is yes, you should have a response plan. And but don't be reliant solely and wholly on that response plan. If one of your staff members is in danger, you need to take what steps are available to you to respond, and my recommendation in that instance would be to involve the police at the immediate level, but certainly not just having a plan, but conveying that plan to the staff and ensuring that people understand it rather than it just becoming a plan that sits in a drawer or gathers dust on a shelf. That's a really important thing.
It's a real risk. You should address it, you should communicate it, and you should document it.
Absolutely.
Okay, let's move towards that date of the 28th September, because when we had a conversation before today, that really alerted me to the fact that a lot of small businesses, particularly those with over 15 employees, are really going to have to start to think about what is the impact upon them should they be faced with structural change to their business, for example, changing the types of work roles in the business, changing the type of work that people are expected to do, the hours, the conditions of their work, or indeed finding out that as a result of the impact of the virus over the time, with JobKeeper falling away and debt coming into the business, that they may have to stand people down or make people redundant. So can you step us through that? Because you said it's a key date for your firm, that 28th of September. What types of things do we need to be aware of?
Yeah, so we know at this point, subject to any extensions that the government might introduce, the JobKeeper regime will finish on the 28th of September. That's a key and critical date. At the moment, a lot of businesses are getting along okay, and that's been a really good thing. The problem, of course, is that it's short-lived, and we've got a period of time now whereby we, should start working towards what things might look like for us as a business coming towards the 28th of February. I think it's inevitable that the number of employees that many employers are carrying at the moment is going to have to reduce from a point in time after the 28th of September when employers need to be ultimately generating sufficient revenue to be able to meet their payroll obligations. So inevitably that's going to result in probably significant redundancies and significant, more significant unemployment across the nation.
Yeah.
The critical things at the moment for employers are starting to turn their minds to what they want their business to look like, or what they think their business is going to be able to carry once JobKeeper comes to an end.
Yes.
Because even if it's extended for some time, which
pushing it out, isn't it?
may or may not occur, it's going to be a problem that businesses are going to face in the short to medium term future. So essentially, sitting down and working out what as a business you need, what as a business you can do without, where you might be able to trim some of your outlays, is a really important thing. And in many respects, this scenario would have facilitated, whilst it's brought some horrible things, to look at it from a glass half full point of view. It's really created opportunities for employers who are, wanting to capitalise on them, and it may mean that many businesses may not come back quite the way they were after the 28th of September, but may come back leaner and meaner, and more readily able to tackle the business challenges that they have. Inevitably, the result of that is usually redundancies. The critical things around redundancies that employers need to be really mindful of is, if that's where you land in your overall planning and revisited model, you need to be across what your outlay is going to be, because redundancy, where you are a business with fewer than 15 employees, subject to what award you might be operating under, because some of the awards have different provisions, but often you won't have an obligation to pay redundancy pay where you are a business with fewer than 15 employees. That is helpful to some employers, but it's not helpful to the ones that have got 15 or more employees, and those guys are going to have to put their hands in their pockets to meet the redundancy pay obligations that they have. That's a statutory requirement. There will be many businesses who will not be in a position to meet those obligations. There are abilities in certain circumstances where there is a genuine inability to pay to make application to the Fair Work Commission to dispense with the obligation to pay redundancy pay. They're not straightforward applications, and they're not granted at the drop of a hat. There needs to be some really careful and appropriately factual consideration around whether that's okay. And many employers have been known to proceed under the basis that, well, we can't pay it, so we're not going to. Or perhaps, well, we've offered that person another job, they're not going to take it, so therefore we don't have an obligation to pay them their redundancy pay. That's actually not right. Unless the Fair Work Commission says you don't have to pay, you have to pay. So that is a big consideration for people to be mindful of. The other pieces of the redundancy puzzle that are often
I was about to
overlooked.
say, you can't stick your head in the sand here. If you're working your way back from that point, if you've done your budget, you've looked at your balance sheet, you've looked at where you might fall in June 2021, that's probably going to trigger a series of actions and decisions. And if you are looking at redundancy, then there are particular periods of time of notice and processes we need to follow. Is that?
Yeah, that's absolutely right. So when you're making employees redundant, you still need to observe their notice of termination and the appropriate periods to be afforded to them there. That's often derived from the National Employment Standards, that sliding scale that exists there in the Act. But to the extent that you may have written employment contracts with your employees, often that notice period prescribes a larger or a longer period of time than what the NES does. So what you need to afford to your employees is the greater of those two, rather than the one that perhaps suits you best. And that's an area where some particularly small business employers, can often trip up. You don't have to give notice. You can pay in lieu of notice if it suits your business requirements better to do that, and often it does for various reasons. But if that's what you're going to do, you have to factor in that payment in lieu of notice, where essentially you're not getting any value for that money into your thinking. The other really important piece is, in these times, in this scenario, it's going to be relatively compelling that the job is no longer required to be done by anyone, given the operational requirements of the business. So often that's a real question in redundancy cases. At the moment, it's probably less of a question, but that is not the silver bullet to avoiding and getting out of any redundancy claims.
Doing it properly,
You need to, don't fall into the trap of overlooking the consultation obligations that exist in awards. You do, for it to be a genuine redundancy that gets you out of an unfair dismissal claim.
You need that genuine consultation.
You need to have had meaningful consultation with the employees to be affected. And the consultation is essentially two-pronged. It's not just having a meaningful verbal conversation that can't just be tokenistic. It has to give the employee an opportunity to actually influence any outcome. It's not just having that verbal exchange. It actually also involves, in most instances, under most awards, a written component. And that written component is so regularly overlooked in these matters, even by larger employers with sophisticated human resources arms. It's regularly overlooked, and it's inherently problematic.
So would you title that consultation, or is it a letter? What?
Often it's just almost like a memorandum type document that sort of says,
and point in time.
And the awards are quite prescriptive around what sorts of things it should say. And so it's ensuring that you're looking to the award, you're looking at what you need to do and you need to say, and ensuring that you're doing it, and where you're not quite sure, that you are essentially, giving yourself the best legal, or putting yourself in the best legal position, reaching out and asking. Again, doing it at that front end may well rescue you from the prospect of a claim at the other side. Not overlooking that as an important consideration.
I think it's really insightful what you said about this isn't a time to clear away acting appropriately, and there is no silver bullet. And I think also many employers and small businesses who may have to shed staff would hopefully re-engage them at some point in time. So there's nothing to stop people either being kind and generous in regards to what exits they provide, and perhaps even extending beyond what they need to provide. And I know some corporates overseas have done that. For example, Airbnb, I know, gave much more than they were legally required to do in terms of leave and outsourcing and support beyond that. So it's a worthwhile conversation. We've got a few more questions and we are getting close to time, so I'm just going to have a look at some of those and see if there's something. Okay. Mary asks, I'm pregnant and I'm very concerned about coming back to work. Can my employer force me?
Essentially, if you are very, very concerned, and that is giving rise to, issues for you that are potentially going to bring the employer itself into a position of risk, it's unlikely that an employer would force Mary to. This is a situation where if Mary makes that approach to her employer absolutely should take advice, because there's a whole lot of other questions that arise from that. I mean, perhaps is Mary experiencing a higher risk pregnancy?
Yes.
What is the medical evidence around pregnant people being perhaps in a more vulnerable position than others?
Yes.
And the same types of considerations apply to employees who are over 70 perhaps, and those types of things. So I think the short answer is maybe, but it's case by case.
Yeah. Okay, we've got about 5 minutes to go. We've just got a quick question here, which I know you'll be able to answer quickly. Jeb asks, what is the NES?
Oh, sorry.
Yeah.
The NES is the National Employment Standards. It is a part of the Fair Work Act. It prescribes 10
boot test they
base,
talk about.
10 base standard terms of employment that apply to every employee.
Okay, another good question here. Benny asks, I have a retail store. If a staff member turns up and work and appears to have a cold or flu, can I send them home? I think my customers will shy away from buying something from someone who seems sick. Most of my staff are casuals.
Yeah. You should send them home. In fact, even better than that, you should get on the front foot and be telling your staff that if they do have cold and flu symptoms, that they are not to come to work, and that they should be letting you know.
Yeah.
So that it's really important that you're protecting the rest of your staff, as well as, you certainly don't want to be that guy who gives, 17 customers coronavirus. So, there are some safety considerations around that. There will also be other considerations around, perhaps when Benny sends that person home, does he have to pay them and those sorts of things. So, again, that's a situation where the short answer is yes, and in fact, it's quite possibly socially irresponsible not to send that person home. But there are other questions and legal issues to be considered in that for advice.
Okay, we'll take one more. Sarah asks, I'm a very senior professional and I understand that people will be let go after JobKeeper periods ends. I fear that I'll be targeted rather than a junior to reduce their wage bills. Do I have any options?
Yeah.
Comes back to that redundancy piece, doesn't it?
Yeah, well, look, it does come back to redundancy. I mean, perhaps one of the fortunate things for Sarah in her situation is, as a very senior professional, she's probably quite highly paid, which means if the employer is doing what we suggested earlier and sitting down and mapping out what their, what the redundancy cost is going to be, and that is a straight up cost, an immediate cost, and it's unlikely to be a low one, subject to perhaps that business having fewer than 15 employees, of course. But Sarah may be rescued by the fact that she's just too expensive to make redundant, but that will, of course, be counterweighed by the fact that she's perhaps too expensive to keep. Certainly, many different types of employees are going to be targets for redundancy. The options, if perhaps sitting down with your employer and saying, listen, I recognise I'm a high wage cost, I don't want to lose my job. Can we talk about me perhaps only working 3 days a week?
I was going to say, there's no rules to say you can't negotiate and get ahead of this. And it doesn't have to become a conflictual legal dilemma.
That's right. That's right. So often these things can be resolved, and even the worries and concerns allayed by actually having a conversation.
Okay. We're towards the end of our time, and I really do want to thank you. And we've had a conversation about you coming back later as we get closer to that 28th of September period, and perhaps some of the issues that we can redress then again. So I'd like to thank Michelle from DWF for being with us again today from the Business Centre. I'd also like to let people know that you can find out more about the New South Wales Government's Small Business Connect program. You can Google it and you can find an advisor near you under the New South Wales Government's Business Connect program. If you'd like to see this webcast again or refer it to others, it goes up on our YouTube channel soon. Please search that, and you can also see Michelle's first one, which we did in March, so you can compare workplace employment issues now and what they were like then. Remember also you can register for the Business Connect program and get a qualified advisor at any time. Finally, I'd like to thank for the last one in this series Jono and Tom from the amazing team at Fortronics who provide the webcast expertise and technology behind this webcast. Been our AV partners right through this period. We can strongly endorse them. If you'd like to talk to us or talk to them, please contact us and we'll put you together. And also, as Michelle said, if you've got a particular question, contact us. We'll pass that on to Michelle and the team at DWF, and we'll perhaps be able to get back with some help. But that's all for now. We thank you very much, and we look forward to seeing you again soon. Thank you.